Anyone else
I concur.
show anything different?
I concur.
Okay, well, good evening. This is the May 28th, 2026 meeting of the Blowing Rock Board of Adjustment. We have a number of things to go over, and then we're going to have a variance hearing on an application from Mr. Paul Thatcher, and I'm assuming that's Mr. Thatcher right there. Very good. We need to approve the minutes of our last meeting, March 26, 2026. Have all board members gotten a copy of those minutes?
Yes.
Okay. I saw one or two small things, but does anyone else have anything that you want to lead off with? Any correction? All right, on the first page, maybe 1, 2, the third paragraph from the bottom, Chairman Springs made a motion to adopt the presented resolution that requires a certified paper copy of town ordinances being used and argued by parties in matters of variances, seconded by Paul McGill. The resolution was intended just for appeals from administrative decisions. It actually says that it doesn't include variances. The reference to Court of Appeals case where the Court of Appeals was fussing because the Board of Adjustment in that particular case didn't supply paper copies of the pertinent town ordinances that were being discussed and argued with in that case. They said you should have paper copies of your town ordinances in the file. So as the variances are much less contentious and much less often appealed to the Superior Court, in the resolution we put other matters, but not variances. You don't have to go to the trouble of bringing in a certified copy of the town ordinance for variances. But the intention is all the parties, including the town, needs to come with a copy of the ordinances they're going to be arguing with and using in their case, stamped by Ms. Huebner, our town clerk. So anyway, I would change the wording of that paragraph to say Chairman Springs made a motion to adopt the presented resolution that requires a certified paper copy of town ordinances being used and argued by parties in matters other than variances, seconded by Paul McGill. And over page 7, I'm sorry, that is all the changes I saw that needed to be made to the minutes. Anyone else have any? I make a motion that we, with that one change I made, we adopt the minutes for the Board of Adjustment meeting on Thursday, March 26, 2026. Do I have a second?
Second.
Mr. McGill, any further discussion? All in favor of adopting the minutes with that one change, say aye. Aye. Any nays? There are no nays. Two other little matters I want to bring up with you. I want to stress to everyone that members of the Board of Adjustment can't go out and do investigation prior to these hearings, can't go out to the scene the property and investigate. We get to drive by the property, take a look at it, and keep on going, and that's it. No investigation by members of the board, please. And of course, no ex parte discussions of the case with anyone else. I'll go ahead and ask, has anyone discussed this case with anyone prior to the hearing?
No.
Yeah. In the last case we had, well, if you have a copy of the minutes, I'm talking about page 7, the second paragraph up from the bottom, Chairman Springs stated that he wanted the section written by Mrs. Garrett about the J.W. Tweeds building being the tallest on that side of Main Street entered into the record. Ms. Garrett noted that the application itself is the basis for the variance and does not need to be entered into the record any more than it already is. They will not change the application after the hearing. Ms. Garrett stated that she needs to clarify what she meant by what she wrote. She can, but she's not going to be sworn. All the testimony that we receive about facts has to be under oath. And if somebody is testifying as to facts, taking questions as to facts, they have to be under oath. And the idea that an attorney can never be put under oath is incorrect. The good folks at the UNC School of Government in their quasi-judicial handbook note that, and I'll mention that the two UNC School of Government professors that wrote this are also attorneys, licensed attorney at laws. But they say in the book, an attorney may represent a party and act on the party's behalf during the hearing. A party or the party's attorney may call witnesses to provide testimony before the board. If an attorney testifies about the facts of the case, those facts are treated the same as those provided by any other witness, and the attorney should be placed under oath and be subject to cross-examination. That paragraph I just read from those minutes where Ms. Garrett said that information is in the application, in the staff report, basically, and it doesn't need to be repeated. Let me read you what, again, the two UNC School of Government professors wrote in their handbook. The record includes all documents, exhibits, and testimonies submitted to the board. So the record includes the application, the staff report, photographs, plans, diagrams, studies, and reports prepared by the applicant, as well as exhibit presented by opposing parties. So it's everything that happens in here and is shown to everyone in here. It's not all admissible, though. Let me continue. Given the nature of quasi-judicial proceedings, some material presented may be incompetent or immaterial. Examples would include general opposition emails from the neighbors, unqualified opinion, or irrelevant facts. This material may remain in the record, but may not be the basis of the quasi-judicial decision. As long as the record includes competent material and substantial evidence to support the board's decision, the admission of other arguably incompetent or irrelevant material does not infringe upon the party's due process rights. The application and the write-up that most applicants do that goes into the staff report, Mr. Thatcher did one nice little write-up just describing what he wants to do and why we should approve it. Until somebody adopts it and speaks it or just refers to it and says that is the truth, I'm familiar with it and I know that's the truth, it's still just hanging out there. It's still just hearsay. So we're going to do what we usually do. We're going to start out tonight on Mr. Thatcher's case, and our zoning enforcement officer is going to go through the staff report and tell us what the pictures are of and who submitted them. He'll give his summary of what he thinks this case is about. That's the first page. And then Mr. Thatcher will give his presentation, and we're going to ask him to read his write-up, his little letter to us, because until he puts it, until he speaks it, it's hearsay. One of us could say, we've read your letter to us that's in the staff report. Is that true and accurate? He said, yes, that's enough. You don't have to beat it to death. But everything in the staff report, the pictures and everything, it needs to be adopted and sort of given seal of approval that it's the truth. Does that make sense? Okay. All right. Tonight, we've got variance number 2026-02. The applicant is Paul S. Thatcher. The location in question is 446 Skyline View Drive. And the zoning at that location is R15 single family. We need to address if any board member has any conflicts, and let me go through the laundry list of things that we have to address for board members. The first is any ex parte communications a board member has about this case prior to the hearing, let us know. It happens occasionally, a citizen walks up and starts talking about that J.W. Tweed's building, blah, 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 and before you know it, you've listened to 5 or 6 minutes, and you go, whoa, wait a minute, I can't talk about that. Well, that's okay. We just need to know that that happened. We'll address it, ask you if it's going to make any difference in the way you rule in this matter. So if somebody comes up and starts talking before you can shut them up, just let us know. It doesn't mean you're going to get it disqualified. You've already told us that there are no ex parte communications, including myself. A member must not have a fixed opinion prior to this hearing as to whether this particular variance should or should not be granted, and should not be biased. Anybody biased against this case or variances in general? No, we're all no. A member must not participate in this case if the member has any close familial, business, or other close relationship with the person involved in this case. Anybody got any conflicts of interest about their relationship with Mr. Thatcher or his property on Skyline View Drive?
I'll add, I have no relationship with Mr. Thatcher. My parents own the property across the street,
Okay.
and my brother lives there.
Okay, all right.
I'll also add, I haven't discussed this matter with any of them.
Do you think the fact that you have family members living across the street would affect your impartiality in this case?
Not.
Thank you, sir. A member must not have any financial interest in the outcome of this case. Does anyone have any financial interest in this case? I'll say no.
No.
Everybody says no. We are not allowed to do any investigation of these cases before the hearing, but we are allowed to go by the property, look at it, and then leave. I've gone by the property from the street, sitting in my car, looked at it. Has anyone else done that?
Yeah.
Everybody done that? All members have looked at the property. Is there anyone here or out in Zoom land? Anyone here other than the town representative? I see Mr. Johnson over there. Mr. Rothrock won't be here tonight. Okay. Mr. Zoning Enforcement Officer is here, represents the town. And Mr. Thatcher is here. He's an applicant. These are parties, people who have a dog in the fight, so to speak. Is there anyone else here or out in the Zoom world that feels like they are a party to this case and they would suffer damage if this case wasn't decided correctly? Anyone else feel that they're a party to this case? And there's no response. The minutes for this case will be kept by a town employee, Ms. Taylor Miller, right here. She actually works in the zoning and inspections office, and the board is going to have an attorney on hand to answer any legal questions that may come up for us, and that's Mr. Joey Petrick, who's sitting down here. He is the town attorney. And Mr. Thatcher, I'm pointing these people out because they work for the town. They are parties. The town is a party. You're a party. The town, if they wanted to oppose your application could. They have every right to do that. It's extremely rare they do that, but they have the right to do it. Therefore, I want to let you know that the minutes are kept by a town employee, and the town attorney is here to answer any legal questions we have. Do you have any objection to these two town employees doing those roles? Very good. No objection. The North Carolina Court of Appeals has said that we need to spell out our procedures for these hearings, and so I'll spell it out. This hearing is a quasi-judicial hearing. It is conducted according to the rules and laws pertaining to quasi-judicial hearings. It will have all of the essential elements of a fair trial. Parties will have the opportunity to give evidence, cross-examine witnesses, inspect documents, and testimony shall be under oath. The board's findings will be based upon substantial, material, and competent evidence. Substantial, material, and competent evidence. And I have how the North Carolina Court of Appeals defines those three if anyone wants to hear it. Does anyone want to hear the definition of substantial and material and competent? No one responds. Good. I am looking at the staff report in this case, which came from the Zoning Inspections Office. Did all board members get a copy of the staff report?
Yep, yes.
And Mr. Thatcher, did you get a copy of it? Very good. You have your copy with you?
I do.
We'll pull it out and let's take a quick look at what we call the 4 factors. That page is headed Findings of Fact.
Oh, yes.
All right, you see the A, B, C, D? These are the things you need to show us that you have in order to get your variance. The first is you got to show us that you have unnecessary hardship. And that's such an odd term. I wanted to speak to you a little bit about it. It's not defined in any statute. It's not defined in any North Carolina court case. It has been defined by the UNC School of Government professors, the people that go to Raleigh and train the legislators in land use law. And they travel around the state and they train county commissions and city councils. They would say unnecessary hardship is where your property is hurt or affected much more than most properties, and it's just kind of like it's not fair. You've got the bad lot on the street. Everybody else has got one that's pretty buildable and pretty easy to work with, but you've got a difficult property because of certain unique factors. So you're going to need to tell us about what makes your property worse in some ways than most properties. Tell us about the hardship. That number B is the hardship that results from conditions peculiar to the property, not something such as you being in a wheelchair. It's the real estate we're interested in, not personal things. C is we want to know if the hardship, we want to know that it didn't result from actions taken by you. If you're the guy that subdivided that lot in 1972 and pointed out where the house was to be sited, you kind of did establish it. If you didn't, we'd like to hear about that, but you didn't. The last one, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such as public safety is secure and substantial justice achieved. substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. So if you're going to hurt or damage some neighboring property, that would come under D. We don't want you to hurt somebody else's property. And we want you to keep in mind that you're asking us to bend the variance rules, bend the law for you, for the construction you want to do, and don't get greedy, I guess is what I would say. Be consistent with the spirit, purpose, and intent of the regulations. All right, we're gonna now swear in everybody that's going to testify. You step over here to Miss Miller. She's got a Bible, and she will get you sworn in.
Secretary Larry, they got it.
That the evidence you shall.
He got me trying to file it where I'll go any second for the motion, any further discussion.
Do by the book.
All right, Mr. Thatcher, generally we start with the zoning inspection officer. He goes through the staff report and tells us what all is in the staff report. Generally, he goes first. If you want to go first, put out what you want to do before he goes, you're welcome to. Would you rather go first?
No.
Okay. All right, Mr. Johnson, you're on. Before you start, let me ask you if you've given all the required public and private notices of this hearing.
Yes, sir.
And did you mail out notices to the nearby property owners?
We mailed 23 notices to 23 properties.
Now, I've just gotten through reading the last hearing minutes, and you did 23 notices for that one. You sure you're looking at the right sheet?
23.
Okay, that's just a coincidence. Don't tell us what anyone said, but did any of the 23 property owners contact you?
We did receive 2 phone calls from two adjacent neighbors.
All right, if you would, starting with your summary, give us the staff report.
Thank you, Chairman, Board. We got for us tonight a variance number 2026-02. Mr. Paul Thatcher. Location is 446 Skyland View Drive, and it is zoned R15 single family. Mr. Paul Thatcher is requesting a setback variance from Land Use Ordinance Section 16-12.4. It's the R15 street setback, which requires a 30-foot street setback. Property is located at 446 Skyland View Drive, further identified by Watauga County PIN 2817-15-4394-000. Again, zoned R15 single family.
Just a minute, let me interrupt you. Did you just give us the setback for the street?
Yes, and I was just getting ready to point that out. Disregard that comment
Okay,
in the first paragraph.
because I get confused real easy. I was assuming you were.
I just called it myself.
Okay.
Let me go to the next paragraph. We're right in the next one there.
Okay.
So Mr. Thatcher is requesting a 5-foot setback variance from the applicable 12-foot southern side setback,
Okay.
which is 12 feet is the required setback on that side. The requested variance is for the construction of a second story with a gabled roof in the same footprint as the existing structure. And we do have some photos of what he's planning with the construction. We've got an elevation of that. The proposed second story will be built over the existing house footprint, utilizing the same foundation. Multiple areas of the existing house already exist and encroach into the front and side setbacks. The portion of the house where the applicant is requesting the variance is considered a non-conforming situation as it currently encroaches 5 feet into the 12-foot setback. The proposed second story will be within the existing encroachment of the existing structure.
Let me stop. And let me ask you about an email you sent us with a revised survey.
Yes, sir.
Did you change the 5 feet to 4.3, or does that 5 feet and the 12 feet still stand? Is that still correct?
That's correct.
Okay.
That's correct. And I'll explain the revised survey here in just a moment.
Thank you. Please continue.
Since the existing house is non-conforming with respect to the side setback, Section 16-8.3B prohibits an increase in the nonconformity by expansion of the nonconforming structure by constructing the second floor into the side setback. For this reason, the applicant is seeking the 5-foot variance for relief. And we basically define the expansion by an increase in dimension, density and dimension for an encroachment. Just a side note, administrative waiver was granted pursuant to Land Use Section 16-12.4.6. A reduction of 7 feet was granted to the street setback along Skyland View Drive. This is based on existing homes in relation to the street. So the new street setback received an administrative staff waiver for Skyland View Drive, which is now 23 feet. And it is noted on the survey in the front now, 23-foot street setback. However, the street setback has no bearing on the request tonight. Going back to the survey, there was a survey sent. The first one that was in your packet. First survey, this is the encroachment side that's in question. The first survey that I'd sent you, this read 7.2, where the 7.7 is. This was a surveyor mistake, and they had revised back to the correct measurement is 7.7 feet. So basically what we had was 7.7 and 4.3. Those weren't adding up to 12 feet. So we got that corrected. So the second survey that you received has the 7.7 feet on it.
Just a minute, Mr. Jones.
It's 7.7 right there. And it's 4.3 from the dotted line up to there.
Right. Which gives us the 12.
Yeah.
That's the distance from the property line to the eave of the house, the existing eave of the house. And the 4.3 is the encroachment to the 12-foot setback here. Make sense?
Yep.
Yeah.
Any questions on that revised survey, or it was just a typo on the surveyor's part?
No, that's fine. If you would, please go through the photos and tell us what they show? Would you rather I just wait and have Mr. Thatcher explain the photo? Looks like he provided them all.
Sorry?
He provided all the photos, right?
No, no.
Okay,
I do have some photos, but it's really.
I'll explain which.
okay.
First building elevation is his proposed construction. And then Paul, correct me if I'm wrong. Explain. This is facing his home at from the street. So the existing home is basically one story here, and the plan is to add the second story here. Currently, the setback is probably in this area right here. So this is the new encroachment that'll be in the setback.
We know what the overall height to the top of the roof, new roof is gonna be.
I don't, but it's under the required 35 feet.
Fair to say that the top of the addition at its highest point is less than 35 feet?
That's correct. You can confirm that, Paul.
It's a standard floor, it's not, no, high ceilings.
I honestly don't even know if it exceeds 30 feet, probably. But it's under the required 35 feet.
Thank you. Moving along.
The first three pictures Mr. Thatcher has submitted himself. I think this is he can explain more in depth in his photos if he needs to. I think this is looking from the adjacent neighbor over towards his house. There's a little parking area there. That's the existing deck that's there. If I'm not mistaken, I believe that's the property line pin right there at the deck, which you probably could reference on the survey. Again, Mr. Thatcher's photo, this looking up his driveway. Edge of the house is right there. And I can't remember, but the property line it's about a foot on that side of the deck right there. And you can see it a little bit better. I think the property line's like right here, runs kind of diagonal. And the last two photos, it's just two I took for reference at the front of the property, showing the one story there. The actual measurement, back to that survey, the actual measurement is 4.3 feet. That's the existing encroachment. Now, I guess at the discretion of the board, the request was 5 feet just to cover any insignificance. I know we've always had questions on forgetting the eave or not the eave. 4.3 is the actual eave. My understanding, Paul, you can correct it, but my understanding is it'll go back to that eave. It'll just be on the second story.
Correct.
Outside of the eave?
Correct. We don't include gutters in that, but it does include the eave. So the request is for 5 feet in case there's any few inch movement if we needed that.
Thatcher, do you have any questions, Mr. Johnson?
I do not. Thank you. Thank you.
Any board member have any questions for Mr. Johnson? Mr. Johnson, I've got a few questions for you. From what you see in the application and the pictures and so forth, and having gone, you have been to the property yourself, I'm sure. With what the applicant is proposing, would it impair emergency vehicles such as fire trucks and ambulances? What the applicant is proposing, would it create a fire hazard? What the applicant is proposing, would it block or impede visibility on any street or highway? What the applicant is proposing, would it, from what you've seen, be contrary to public health and/or safety? No further questions from any board member? Mr. Thatcher? No further questions?
No.
Okay, thank you, Mr. Johnson. Mr. Thatcher, tell us about what you want to do, and
Do you want me over here? Just over here.
if you come up here to the microphone.
First off, I'd like to thank everybody for showing up tonight. I appreciate spending your time. I know there's probably better ways you'd like to spend your time. I came to this town. I looked for a couple of years for a property. Found this particular one in town simply because I wanted to be close to the downtown area. I'm really glad that I did, even though it's a smaller property than I would have liked. I have 2 children. I really need that extra space to be able to house them when they come. And I actually have a daughter that's 14 that lives with me. You want me to read this statement? I'll go ahead and read it. The attached plan completed by Coffey Architecture. By the way, it's John Paul Coffey is the one that did all the architectural work. And I made no input to him other than what I was looking for. He supposedly worked on all these setbacks. After we filed the plans is when we realized that we were actually violating the side setback. The attached plan completed by Coffey Architecture would add a second story to my approximately 1,400 square foot home, Blowing Rock, 2 bedrooms. The proposed addition would in no way change the structure's existing footprint. The current home, built in 1972, was constructed prior to the setback requirement, to my knowledge, obviously, because I don't think it would have allowed that. However, while conducting a survey of the property, it was found to be slightly inside the new side setback. Therefore, I'm requesting a variance. The requested variance does not increase the structure's encroachment into any required setback. I understand there's a difference of opinion. Nor does it increase lot coverage or intensity of use. The structure's nonconformity status arises solely from its lawful construction prior to adoption of setback requirements. The proposed vertical expansion maintains the identical footprint and therefore does not increase the degree of nonconformity. Strict application of the ordinance would impose an unnecessary hardship unique to this particular parcel by effectively preventing reasonable modernization of a lawful structure that cannot be feasibly relocated without substantial demolition. The requested variance represents the minimum deviation necessary to preserve the owner's vested property rights while maintaining consistent with the spirit and intent of the zoning ordinance. I'm not an attorney, so perhaps this is not relevant information, but I did notice that there are quite a few properties on that street that violate the setback. I mean, there's one in particular here that's, I mean, very close. They can't be more than, I don't know. I have spoken. This is the first time I've met Linda here. But my other neighbors I've spoken to and shown them these extended drawings just to explain what I wanted to do and get their feedback. And I'd say everyone that I talk to seems to be in favor. They seem to think it's a great idea. It increases property values. It's not going to harm the look of the neighborhood. It should beautify the home. Questions from that?
Any board member have any questions?
Yeah, I have a question. So did you look into what it would cost to extend the house back into the lot, keep on a single level?
I don't think it's possible, at least from a cost perspective, simply because the lot slopes dramatically down. Okay. And in fact, there's retaining wall there, so you have very limited space to be able to do something like that.
Got a couple of questions. The slope at the rear is news to me. Tell us some more about the slope and how steep it is.
Extremely steep. I mean, getting up in years, but when I walk back there, I have to really caution myself against falling downhill. It's very steep, extremely steep. As a matter of fact.
You said a number of the neighbors are suffering the same.
Well, I just noticed, I took several pictures of properties on that street where the setbacks are obviously not conformed with because the homes are very close together. Again, the properties were all built, I assume, around the same time. I don't know. But,
Right. Do those houses also have the steep slope, or does it vary in the neighborhood?
well, the other side of the street does not have a slope, to my knowledge. Well, I take that back, but maybe they do. I mean, it would depend on the individual lot. But I just know that right there where I'm at, I've got just drops straight down. So effectively, the only place they could have put that house is where they put it. There's really no moving it or expanding it.
I have to say, I was really curious as to why it's crammed up on the street.
That's the reason. That's the only place they could have put it and gotten all those facilities in there.
Would you say the slope at the rear of the house is unbuildable on the slope?
Oh, yes. Yes, I would. I mean, again, I'm not an expert, I'm not a builder, but that's pretty much when the architect looked at it, coffee, that's what he said.
Back in 1972, I have to ask, were you responsible for the siting?
I was 11 at the time. No, sir, I wasn't.
So you didn't subdivide the property and site the house where it is now?
I did grow up in a home very similar to that, though, up in the Northeast.
Any further questions from anybody? Mr. Thatcher, thank you.
Thank you. Thank you for taking the time. I really appreciate it.
Any further discussion? You want to go ahead and go into the facts? Any further discussion? David? Findings of fact. The applicant is Paul S. Thatcher. The owner of the property in question is Paul S. Thatcher. I didn't actually ask you that. Let me ask you now. Don't let me forget to close the evidentiary. The address of the property in question is 446 Skyline View Drive in Blowing Rock, North Carolina. And it was built in 1972. The Watauga County PIN is 2817-15-4394-000. The property is zone R15. The applicant wants to do the following, which would violate zoning regulations and which would require a variance. Wants to build a second story on the existing one-story house. The second story would be on the existing house footprint, utilizing the same foundation. The existing house is non-conforming to setback requirements, but is lawfully grandfathered. And if I misspeak or make a mistake, please, fellow board members, jump in and stop me. The new second story would encroach, what was it, 4.3?
Well, we're going to say 5.
All right, let's say it encroaches 5 feet into the required 12-foot side setback requirement of Blowing Rock Ordinance 16-12.4. The applicant is seeking a variance for that 5-foot encroachment on the south side of the property. The Blowing Rock Zoning Code Ordinance section, which is at issue here and which stands in the applicant way, is 16-12.4.
You don't mind, I should add, I would rephrase that, the encroachment is 4.3 feet,
Okay.
but the requested variance is 5 feet.
Okay.
That's two different things.
Yeah, that's good.
Okay,
That's better.
I like it. And it was 4.3,
Yeah.
okay. And but he's seeking a variance for 5 feet. Put into words the ordinance which stands in his way. The ordinance requires a 12-foot side setback from the property line with no construction allowed in that 12-foot setback. Continuing the height of the proposed second-story addition of the proposed second story would be less than 35 feet. There are not other parties withstanding to come into this case and hearing. The applicant did provide drawings or sketches or plans or pictures illustrating what the applicant wants to do. The town of Blowing Rock has provided and given all necessary legal notices of this case and this hearing. There was proper notice of this case and hearing given to all property owners with property abutting the parcel of land which is at issue here. And proper notice was given to any other persons entitled to receive notice. The applicant did receive a copy of the planning directors of the zoning enforcement officers. Staff report prior to the hearing. There were not other witnesses in this hearing besides the applicant and the zoning enforcement officer. What the applicant is proposing would not impair emergency vehicles such as fire trucks and ambulances. What the applicant is proposing would not create a fire hazard. What the applicant is proposing would not block or impede visibility on any street or highway. What the applicant is proposing would not be contrary to public health and or safety. Unique features of this property include. Yep.
I'd like to move to reopen the public hearing to ask Brian one quick question.
Sure, we haven't closed it yet.
Okay. Brian, the very first photograph after that slide. Is that the retaining wall that was mentioned? Is that facing towards the back of the property?
That's actually the driveway for the adjacent property, and that's his retaining wall for his driveway.
I think the retaining wall he's referencing would be down below this.
Oh, I see.
So if I'm standing there, am I facing the direction the back of your house faces?
Facing in the woods in the back.
That shows the drop off. Is that accurate?
It's hard to see from that picture, but it is.
I can tell that it's dropping off.
Yeah.
Yeah, because the trees are way down
To give you an idea, to see the homes that are built about behind it, you really, I mean, you're looking straight at it.
I was looking for something that we have in front of us.
The previous photo is probably taken over here.
Okay, thank you.
Let me. Go back to fact number 10, that's talking about the notices. And let me add that the zoning enforcement officer received, the zoning officer did send out 23 notices to nearby property owners. Unique features of this property include property lot is quite long on the sides and narrow at the end. The existing house takes up almost all of the street end, Skyland Drive,
Skyline View Drive.
Skyland View Drive, street end of the lot from the north side to the south side. Takes up almost all of it. The terrain at the rear of the existing house is a steep and unbuildable slope. Are there any other facts that any board member would like to add? I move that we close the evidentiary hearing. Is there a second? Mr. Schiller, seconds. Any further discussion? All in favor of closing the evidentiary hearing and moving on to conclusions of law, say aye. Aye. Aye, it's unanimous. Conclusions of law. Based upon the evidence presented and the facts. And by the way, let me, as I always say, I have written this up in the form of a motion. I have to write it up as motion passes or the motion fails. In my habit, I always say motion passes. But of course, when we take the vote, if you think he's failed to meet his burden, you would vote a nay. So these are written up as positive, and if you disagree with that, you would vote no. Does that make sense to everybody? Okay. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. I would add at this point, the existing house is almost at the street, Skyland View Drive Street. And there is a steep slope, a steep unbuildable slope just behind the existing house. Such that any addition would need to be on the actual ground where the existing house sits. All right, so I make a motion to find that Mr. Thatcher has met his burden and that based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. The existing house is almost at the Skyline View Drive street, and there's a steep, unbuildable slope just behind the existing house, such that any addition would need to be in that actual ground where the existing house sits. I move we find he has met his burden and has met the requirements of factor number 1. Is there a second?
Second.
Walker seconds. Any further discussion? No further discussion. All in favor of finding Mr. Thatcher has met his burden for factor 1, say aye.
Aye.
Aye. It's unanimous. Second factor. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial, material, and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. Variance may be granted when necessary and appropriate to make reasonable accommodation under the Federal Fair Housing Act for a person with a disability. I would add, the fact the existing house location is really the only buildable spot on the lot. Due to a very steep slope, very steep, unbuildable slope directly behind the house. All right, so I make a motion that we find that based upon the evidence presented and the facts shown above, Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodation under the Federal Fair Housing Act for a person with a disability. The fact that the existing house location is really the only buildable spot on the lot due to a very steep slope, unbuildable slope directly behind the house. Creates a condition that is in the minority of the neighborhood as a whole. All right. So I make a motion that we find that Mr. Thatcher has met his burden for factor number 2. Is there a second?
Second.
Miguel seconds. Any further discussion on that factor? Further discussion? All in favor of finding that Mr. Thatcher has met his burden on factor number 2, say aye. It's unanimous. Moving to number 3. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material competent evidence exists to conclude that in this case, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The applicant and nothing whatsoever to do with the subdivision of a lot or the siting of the existing house. All right, I make a motion that based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material competent evidence exists to conclude that in this case, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The applicant had nothing whatsoever to do with the subdivision of a lot or the siting of the existing house. I make a motion we find he's met his burden on factor number 3. Is there a second?
Second.
Second by Mr. Goodson. Any further discussion on factor 3? There is none. All in favor of finding that Mr. Thatcher's met his burden and is satisfied? Factor 3, say aye.
Aye.
Aye, it's unanimous. Moving to factor 4, based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. Substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. I would add, by placing the new addition on top of the footprint of the existing house/foundation. By placing the new addition on top of the footprint of the existing house and foundation, construction does not reduce the existing, what would you call it, clearance between the two properties, existing space between the two properties? Distance. Does not reduce the existing distance.
The two structures.
Or proximity. Making the addition more compliant with the zoning laws. All right, I make a motion that based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice achieved. Substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. By placing the new addition on top of the footprint of the existing house and foundation, the new construction does not reduce the existing distance or proximity and makes the addition more compliant with the zoning laws. Make a motion that we find that Mr. Thatcher's met his burden on factor number 4, and that based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. Substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. By placing the new addition on top of the footprint of the existing house and foundation, the new construction does not reduce the existing distance or proximity and makes the addition more compliant with the zoning laws. I make a motion that we found he's met his burden. Is there a second? Second. Mr. Schuler seconds. Any further discussion on factor 4? All in favor of saying that Mr. Thatcher's met his burden and it's complied with factor 4, say aye.
Aye.
Aye. It's unanimous. The Board of Adjustment does grant the applicant a variance to take the actions stated in fact number 5 above with the board, period. There's no conditions attached. There are not additional conditions ordered by the board. This decision is effective.
Was that your motion for those two? I have additions. Both.
Okay, you're right. Got ahead of myself. Thank you, Mr. Walker. Let's back up. Conclusion of law number 5, the Board of Adjustment does grant the applicant a variance to take the actions stated in fact number 5. Yes, sir.
I would include a change to the facts or the request in number 5 to allow a 4.3 foot variance plus gutters, not a 5 foot variance.
Let's see. We said the new second story would encroach 4.3 feet into the required 12-foot side setback. And the applicant is seeking a variance for 5 feet on the south side of the property. Does that hit what you were talking about?
Yeah, so I think it's a change in the 5th legal finding that the variance, if we grant it, is 4.3 feet, not.
I see what you're saying. Sure.
I believe that was the right kind of happen, or to suggest that.
To take that action stated in fact number 5, comma, with the understanding that, finish it off, Mr. Walker, with the understanding that,
Well, the building permit will allow for a 4.3 foot setback, not a 5 foot setback. 4.3 foot setback variance, not a 5 foot setback variance.
well, he wants to have a little fudge factor, a little,
If the survey says it's 4.3 feet, I don't want to fudge factor even an inch coming beyond that. The existing building's 4.3 feet.
all right. All right, let's take a vote on it. Fair enough? You want to go ahead and make the motion?
I move that I move that we approve a variance of 4.3 feet, not including the gutters, rather than the 5 feet requested by the applicant.
For the discussion, I would just say, I don't feel like the 7/10 of a foot is gonna make that much difference one way or another.
Mr. Johnson suggested that. He suggested a 5-foot.
I think he can make 4.3 work if you so wish.
Somebody says,
His surveyor will probably have to verify that, though. I don't think I have that ability.
all right, well, there are arguments to be made for both ways. Let's go ahead and take a vote. You want to go ahead and say all those in favor?
All those in favor?
All the nays? I'm a nay.
Your name.
All right, so we're going to change it to, he's asking for a 4.3.
He's asking for 5 feet.
Are you asking for 5 feet?
Yes.
Or is that Mr. Johnson?
Really, I just want to build my project. I don't know when, you know.
I think it was just working with a whole number and giving a little bit of flexibility.
Okay, so we've got 4 saying it needs to, not, the application needs to be for 4.3 and not 5.
Yeah, I mean, that's what his plan is.
Okay.
It'd be 4.3.
All right. Let me go back. We're gonna have to do a motion to reopen the evidentiary hearing. Yeah,
I think we have to do that. Wouldn't we just, this is part of factor
Yeah, just take the thing out about
legal, no, the legal, that's still what his request is. That hasn't changed. Factor 5 has not changed. What is changing is what we are finding under the conclusions of law.
I see what you're saying. So we don't have to change the fact. He's asking for 5, but we're giving him 4.3.
Exactly.
All right, all right. So it does grant the applicant a variance to take the action stated in number 5 with the exception that the variance is for 4.3 feet and not the 5 feet that was requested. Does that get it? Yeah. Okay. The board does grant the applicant a variance to take the actions stated in fact number 5, with the exception that the variance is 4.3 feet and not the 5 feet that was requested. So that's the motion. Is there a second? Mr. Schuler seconds it. All those in favor of adopting conclusion of law number 5, as I just articulated, say aye.
Aye.
Aye. It's unanimous. And there are not additional.
Let's go through that.
You want to do 6? Okay. All right. There are additional conditions ordered by the board.
I would move that an additional condition be that the building permit that is granted to the applicant include a very specific requirement regarding parking for contractors, for workers, et cetera. And that be explicitly on the building permit.
Well, what kind of parking restrictions you want to have?
No double parking, no parking in the neighbors' driveways,
Okay. All right.
no impeding traffic.
There are additional conditions ordered by the board regarding parking of vehicles during construction.
Yes.
And what do we add in placement of materials? during the construction of the second story. And those conditions are, what's your first one, Brian?
No parking of construction or other vehicles associated with this application on other private property.
And parking of construction vehicles? On private, on neighboring private property?
Yeah, neighboring properties, however you'd like to phrase it.
Do you have a second?
The second part, regarding placement of materials only on the applicant's property at all times.
Construction materials to be placed on the applicant's property at all times. Okay, you got any more?
That was all.
All right, so we make a motion that as a condition as a condition. As a condition for this variance, a condition for this variance is ordered by the board regarding parking of vehicles and placement of materials during the construction of the second story. And those conditions are no parking of construction vehicles on neighboring private property, and materials are to be placed on the applicant's property at all times.
I'd modify that, not construction vehicles, any vehicle.
So you're suggesting using one lane of the narrow road there?
Not taking a position about double parking.
Okay, so I had no parking of construction vehicles.
Any vehicles.
No parking of,
Any vehicles associated with the applicant or this project.
Could we add to that, unless the builder or the owner gets permission in writing from some other person and from a neighbor and gives it to Mr. Johnson?
That's fair, yeah.
all right, let me start over. This is getting too messy.
Some of the neighbor. is that cul-de-sac at the very end, it's really not a cul-de-sac, it's just dead end, but it's wider down there, is that?
It's turnable.
Yeah, it's turn by turn on, but is it,
Bigger vehicle.
is that city? That's city road, they just widen it right there.
Bigger vehicle might have a hard time turning, but
Yeah,
they can make
yeah,
it.
so you're gonna have to back and go around, yeah.
No parking of any vehicles associated with this construction project on neighboring property unless written permission is given by the neighboring property owner. Is that good?
And submitted to Mr. Johnson, the permission submitted. I think there'll be willing neighbors there, you know.
The town don't need permission from a private property.
Yeah,
Our goal will be to enforce anything in the street.
placate, yeah.
So we'll leave out Mr. Johnson.
Yeah, we're making, knock that out, yeah.
No parking of any vehicles associated with this construction project on neighboring property unless written permission is given by the neighboring property owner. Is that good?
Yeah,
And then the last was materials are to be placed in the applicant's property at all times. All right, so the motion is for there is a condition ordered by the board for this variance, and that is regarding parking of vehicles and placement of materials during the construction of the second story. And these conditions are no parking of any vehicles associated with this construction project on neighboring property unless written permission is given by the neighboring property owner. And materials are to be placed on the applicant's property at all times. Construction materials are to be placed on the applicant's property at all times. So I make a motion that we find that we've made that condition, which is a requirement of the variance. Is there a second?
Second.
Mr. Walker seconds. All those in favor say aye.
Aye.
This decision is effective after review and approval of the written decision by all participating board members and then filing with the clerk. And the Board of Adjustment did adopt the above listed conclusions of law. I make a motion we adopt all of the conclusions of law as just stated and voting upon. Is there a second?
Second.
Mr. Goodson seconds. Any further discussion on all of the conclusions of law?
No.
All in favor of adopting the conclusions of law, if you've just gone through them, say aye.
Aye.
Aye, it's unanimous. Mr. Thatcher, you got your variance.
Thank you. Thank you all.
Ms. Miller, I'll get this to you next week.
Okay, thanks, everybody. See you.
Good to see you.
Later, have it.
Taylor, how's Stevie doing?
Try to get it right there.